Judge Carl Nichols has recently taken a significant decision in the ongoing case concerning the immigration papers of Prince Harry, directing the Department of Homeland Security, DHS, to provide sensitive information for his consideration. The judge expressed his concerns that the arguments presented by DHS lack the necessary detail for him to reach a fair decision. Consequently, he requested the agency responsible for immigration oversight to furnish declarations that would elucidate the specific harm that could potentially result from disclosing the Duke of Sussex's visa application to the public. This development unfolded subsequent to a recent hearing held in Washington, during which Judge Nichols attentively listened to arguments presented by both DHS and the Heritage Foundation. Notably, the Heritage Foundation has been advocating for the release of the documents in question, having submitted a Freedom of Information request last year. Their request stemmed from suspicions that Prince Harry may have misrepresented his drug use in his immigration paperwork, despite openly discussing it in his memoir and on a Netflix show. The failure to disclose accurate information on his entry forms could potentially lead to Prince Harry's removal from the US or rejection by border agents. In response to these contentions, Judge Nichols asserted the authority granted to him by the Freedom of Information law to conduct a private review of contested records or declarations. This review, he emphasized, would aid him in determining whether any exceptions preventing the public release of the documents were applicable. Judge Nichols underscored the appropriateness of conducting such a review when agency affidavits lack sufficient detail for meaningful review of exemption claims, particularly in cases where the number of withheld documents is relatively small and the dispute centers on the content of the documents themselves. In his filing to the Washington court, Judge Nichols stressed the necessity of an in-camera review to ascertain whether the disputed records fall within the scope of the claimed exemptions. He set a deadline of March 21 for DHS to submit declarations detailing the records being withheld and the potential harm arising from their public disclosure. The review, as specified in his order, will be conducted privately by the judge himself. In his memoir released last January, as well as in the Netflix series chronicling the lives of the Sussexes, Prince Harry openly discussed his past drug use, including his experiences with cocaine and marijuana, attributing the therapeutic effects of cannabis to coping with the trauma of his mother's death. Despite this transparency, the Heritage Foundation alleges discrepancies in Prince Harry's US visa application from March 2020, particularly regarding his responses to questions about drug use. The foundation contends that the sensitivity of the documents lies in their potential to disclose Prince Harry's immigration status in the US. While DHS argues that Prince Harry, despite his celebrity status, retains a right to privacy, the Heritage Foundation asserts that his public disclosures about his private life waive such privacy rights. During a recent hearing, DHS lawyers cast doubt on the veracity of Prince Harry's claims about drug use, suggesting that they may have been included for commercial reasons rather than as sworn testimony. Former President Donald Trump has also weighed in on the matter, hinting at the possibility of revoking Prince Harry's US residency if re-elected. He cited perceived betrayal against the Queen and indicated that Prince Harry would be left to navigate his situation independently under a second Trump administration.